Now, the Ethics and Anti-Corruption Commission, the Attorney General, the Office of the Director of Public Prosecutions and Transparency International Kenya have written to Parliament opposing a bill by Mbeere North Member of Parliament seeking to amend existing anti-corruption laws, terming it, quote, retrogressive.
In the law, the legislator seeks to have 2 corruption offences deleted, a move the opponents say will hinder efforts to enforce accountability among public officials involved in the administration of public resources. Martin Munene has the details.
And Anti-Corruption Commission, the Attorney General, the Office of the Director of Public Prosecutions and Transparency International Kenya have raised red flags over a bill before the Justice and Legal Affairs Committee at the National Assembly. The Anti-Corruption and Economics Crime Amendment Bill 2023, sponsored by Mbeere North MP Geoffrey Ruku, proposes to delete sections 45(2)(b) and (c), which criminalize failure to comply with procurement guidelines or engage in a project without prior planning. EACC in a memorandum to Parliament maintains that the deletion of the 2 key corruption offences will remove essential mechanisms for enforcing accountability and create legal escape routes for perpetrators of corruption, thus opening a floodgate of corruption scandals in the country. The ethics body in the document says public procurement accounts for between 10% and 13% of the gross domestic product, thus the need to protect the great proportions of public resources expended through public procurement. The Attorney General on his part saying that the proposed amendment, and I quote, is not in line with our anti-corruption policy framework and international obligations that call for strengthening of the legal framework for combating corruption. The AG holding that the amendments remove procurement, fraud and malpractices from the ambit of corruption and economic crimes. The Office of the Director of Public Prosecution also weighing in on the matter before the Justice and Legal Committee, saying they are opposed to the deletion of section 45(2)(b) as the amendments would have far-reaching implications that would negatively impact on the legal mechanisms established to protect the public from theft of public resources. The ODPP saying that procurement processes constitute the greatest exposure with respect to corruption within the public service, and thus the need to have the existing procurement laws and regulations in place to protect the public from corruption within the public service. The ODPP also maintaining that the offence of engaging in a project without prior planning was meant to protect the government from potential legal actions. The proposed amendments have also attracted the criticism of non-state actors, with Transparency International saying that it is opposed to the bill in its totality. Transparency International holding that the bill goes against the public interest, the principles of public finance, leadership and integrity standards, and the national values and principles of governance, which include accountability, rule of law, good governance, and integrity. The organization saying that criminal sanctions for corruption offences serves to hold perpetrators of corruption liable and acts as a deterrent. Martin Munene, Citizen TV.